Boys and girls, ladies and gentlemen, children of all ages. You know, it's always one of those nice things to see when you see somebody push back against the Walt Disney Company and actually get to watch them back down. And that's exactly what we've got here today, ladies and gentlemen, because after the absolutely outrageous argument made by Disney's lawyers that a terms and service agreement on a trial for Disney Plus, a 30-day free trial, was going to apply to something that happened inside of the Walt Disney parks is absolutely insane. And it looks like after their Disney lawyers decided to stupidly put this out there into the world and try to use this as a kind of an excuse to get this case completely and totally dismissed, they are finally backing off of such a ridiculous argument that I don't think any reasonable judge in his mind would ever actually consider to be valid in any way, shape, or form. And although I am obviously not a lawyer, I don't have any kind of expertise in this and that kind of stuff, I am just your humble common nerd. A little common sense here, which I know is very lacking in a lot of the modern era these days. A little common sense would go a long way to have this simply seen as nothing more than the ridiculous argument it was right from the very beginning. So we've got an article over here from the Wrap.com in this particular case right here about Disney completely and totally backing off, and that is something that is very good to hear. The House of Mouse is not the behemoth that everybody believed it to be, that you could not challenge and you could not win. Disney's actually got a lot of crazy lawsuits going on right now with the Gina Carano situation, dealing with Disney Star Wars, and then of course this now as well. It should be very interesting to see how all of this ends up panning out and what a judge thinks about all this, and of course what a jury trial will actually end up showing us if for some reason they do not figure out a way to settle this out of court, because trust me, discovery is something that Walt Disney Company never wants to actually get to, and boys and girls, that is one of the most juiciest things we can all absolutely hope for, to see Disney exposed as the absolutely insane and evil doing company that they have been for so very long. So, before we get into this article from the Wrap.com and give you all of the juicy details and seeing what their excuses have been before all of this, if you do enjoy our content, hit that like button, share with all your friends, and subscribe or follow if you have not already, boys and girls, because we are grinding, we are growing, we are getting inching our way closer and closer to 1,200 subscribers, and I could not do that without every single one of you. Also, leave us a comment down below. What do you think about all this? Was this a ridiculous argument from the begin with, or do you think something like this could actually be legally binding if the judge was willing to allow it? Let us know what you think about all that down below. Disney backs off using Disney Plus arbitration clause to squash wrongful death suit. The company came under fire after its lawyer cited the streaming service user agreement. I mean, literally, we made videos roasting them over this. A lot of people made videos completely and totally roasting about them. There was all kinds of articles. This was nothing more than a bad PR, disastrous dumpster fire for the Walt Disney Company. So Disney moved to undo a PR disaster of its own making on Tuesday, formally withdrawing a request to force a wrongful lawsuit to be settled out of court that cited the Disney Plus user agreement. The lawsuit was filed in February by Jeffrey Piccolo, whose wife, Kanakaporn Tazongini, died in October 23 after having a fatal allergic reaction to food she was served at a restaurant at the Disney Springs shopping mall in Buena Vista, Florida. The lawsuit states that she had been assured her dish did not contain anything she was allergic to. And this was something that, according to the original lawsuit filed, this was something that was cited over and over again that the employees told them several times. She specifically told them that she was allergic to nuts and milk, and that this is one of the situations where you couldn't be in contact with any of that, or you would be something very, very bad would happen, and that's the situation we find ourselves in now. The lawsuit states that she was assured her dish did not contain anything she was allergic to, but Disney was noted that the restaurant is independently owned and operated and not under their purview, so they're trying to also wiggle their way out of this as well. Disney lawyers moved to have the case forced out of court after learning that in 2019, Piccolo had signed up for a Disney Plus free trial. Yes, not even a current Disney Plus subscriber, but someone who had signed up for a Disney Plus trial over 5 years ago, boys and girls, 5 years ago. That is absolutely insane. The company argued that the Disney Plus user agreement that mandates arbitration for any Disney Plus dispute somehow applied to literally any conflict that the user may have with Disney. That is mind-boggling to think that a terms and service agreement, something that almost no one reads all the way through for a free trial for a streaming service, would apply to your experiences at a park, spending hundreds of dollars, if not thousands of dollars on these parks. That's mind-boggling. That's absolutely mind-boggling. Disney's lawyers forced to have it. A court hearing on Disney's motion was initially set for October 2nd in Orange County, Florida, but has now been canceled. Boy, I wonder why. Could it have anything to do with all of the media backlash, or did someone over there at Disney's lawyers group over there just decide to go, hey, stupid? I get the legal argument you're making, but have you ever even been in a courtroom? Any judge is going to laugh you out of court for trying to cite something as ridiculous as a terms and service agreement for a free trial. The ridiculousness idea that anybody think that would apply to what happens in the parks is absolutely mind-boggling. With such circumstances as the ones in this case, we believe this situation warrants a sensitive approach to expedite a resolution for the family who have experienced such a painful loss. Chairman of Disney Parks said in a statement, as such, we've decided to waive our right to arbitration and have the matter proceed in court. Oh, yes. We're the good guys, our kind, generous souls over there at the Walt Disney Company decided to just go ahead and waive our arbitration argument, even though it was resoundingly a stupid and ridiculous argument that a judge was going to laugh you out of court coming October. And after all of the backlash, and probably after you consulted with some attorneys who actually had some common sense, they told you this was a really stupid argument to try to make and that you would get laughed out of court by doing this. So, to save them any even more face, to save them what face they possibly have left in the public eye out there, they decided to not go this way. Color us shocked there. Don't believe their BS. How do you know when a lawyer's lying? Their mouth is moving. Same thing with politicians. Although Disney has withdrawn the motion, the arbitration clause they relied upon in their motion still exists on their various platforms. This potentially puts other people injured by Disney's negligence at risk of facing a similar legal challenge, Piccolo's lawyer Brian Dempsey said. After the lawsuit was filed, staffers at Regal enrolled to the New York Post in February. I don't know if this is because of the incident, but now the first thing we ask when we take the order is whether anyone at the table has any allergies. And why would they have to ask that now? Because this was a restaurant that was advertised on the Disney website as being hypoallergenic safe. That if you had a lot of allergies out there, this was a restaurant you could go to and not have to worry about things. Well, guess what? That turned out to not be true in any way, shape, or form. And now a woman, a wife, a mother is dead because of that. So yes, someone needs to be held responsible. And the fact that they even tried to put this argument out there, the reason they are withdrawing is know they were going to get laughed out of court, and this was going to set a precedent going forward that they would never be able to use this as an excuse again. And that is what Disney was most afraid of, because they want to be able to continue to use this as a scare tactic to try to get pushed out there. Because let me tell you something about how lawyers try to get away with legal contracts. They will shove anything and everything they possibly can to make sure that their client is not responsible for anything as soon as you sign on that dotted line. But here's the problem with that. The majority of those contracts never, ever get challenged in court, because the majority of the time stuff like this doesn't happen. But when it does, and a lot of that stuff gets challenged in court, more often than not, those kind of ridiculous things get thrown out. Much like the FTC recently ruled that non-compete clauses are illegal and non-enforceable when it comes to employment contracts. This is the exact same kind of thing. They withdrew their argument because they didn't want a judge to have this thrown completely and totally out of court, so that way Disney's scary big end lawyers that they pay millions of dollars for every single year could continue to use this as a scare tactic to try to scare off smaller law firms and smaller people out there that didn't have as big a cojones as these people did to try to push back and challenge this kind of thing, because they knew as soon as this got thrown out, it would apply to absolutely everything, and they would have been ruined going forward as using this as an excuse. The only reason they withdrew this is because it's got as much limelight as what it did and how dumb an argument this possibly was. But at the end of the day, we're not quite done with this court case. We've got a lot of stuff left to go on. We'll have to wait to see if Disney tries to settle this just to make it go away, or if we end up getting all the way to a jury trial, discovery, and all of the other fun stuff that will expose the evil workings of the inside of the Disney Corporation that we have all known and suspected have been going on for a very long time, boys and girls.